It's a pleasure to be here with you to talk about what is a critical challenge facing land conservation throughout the world. And I'd like to share with you the experience of cross-border conservations in North America, and not with respect to telling you how to do it and how to solve all the problems, but to giving you some illustrations of some of the ways in which we've tried to overcome that as a barrier. I'll share my screen. So first of all, I'd like to just mention a couple reasons why cross-border land conservation is critical. We live in, as you all know, a greater and interconnected world. Something we've learned through the pandemic and through the greater use of internet. We've seen a growth in citizens who have an interest in conservation other than the countries that they may live in. We also have seen land uses and land conservation challenges that have impacts beyond the borders of an individual country. And so there are obviously issues that arise from our land conservation goals and objectives. And this is certainly true with our greater understanding of the need to approach conservation from a landscape scale perspective. And in doing so, we often face projects that have transboundary objectives, that is, conservation objectives that extend beyond the boundaries of a single country. And as the environmental movement knows, we are always thinking globally, but we need to act locally. So it's helpful to think about cross-border conservation, as some of the previous speakers have said, from a fact pattern. And I like to think of it, an owner of land owning land in one country who happens to have tax obligations in another country wants to see that land protected in the first country, even though they may be paying taxes in a second country. Often they are interested in making an outright conveyance of land as a gift. And in some cases, they are interested in conveying land in the form of an interest in land in the form of a conservation easement. And as the previous speaker has talked about, very commonly, the donors and taxpayers in one country will want to financially contribute to support a charitable conservation organization in another country. So it's helpful to think about these fact patterns as we think about the tax treatment for the ways in which these transactions are structured. In the US, under US law, contributions made by taxpayers are deductible against otherwise taxable income. So it acts as to reduce your taxable income when you make a gift of land or cash to a legitimate charity. However, one major rule is that those contributions must be to or for the use of a charity created or organized under the US. And so this, the different forms of gifts, these gifts must be made, even though it's a form of land or cash or easements, they must be made to an organization which is created or organized in the United States. And if you make a gift to an organization that is working with a conservation organization in another country, conflicts arise between the tax treatment in the US versus the tax treatment of a gift of land in another country. In other countries, it's often the case that a gift of land in that country may trigger a capital gains tax on the disposition of that property. And so having these two tax systems interplay with one another is often the challenge. There are three strategies that have been used to try to address this challenge. One of which has to do, one strategy involves the reconciliation of these tax treatments in the form of tax treaties between two countries, in this case, the US and Canada. And in 1984, US and Canada ratified a tax convention that supersedes domestic tax legislation in both countries. And what the provisions of the tax treaty provide for is that the property located in the I should say that the taxpayer in the U.S. or Canada can deduct a contribution to a U.S. or Canadian conservation charity and take a deduction for the extent it would have been eligible for a deduction under the U.S. or Canadian charity laws. But it's limited to the extent that that taxpayer has source income in that country. And this is, it's often the case that otherwise the jurisdiction, the US or Canada, would have the right to tax the gains on the disposition of that property where it's located. A second strategy that has been used is the creation of what are called American Friends of organizations. And these are organizations that obtain favorable tax treatment in the US as well as other jurisdictions, as long as they have a charitable purpose to support a charity in that other country. And the best example of this approach is something called the American Friends of Canadian Conservation. And it is organized as a US domestic charitable corporation with US tax exempt status. And it has secured status as a prescribed donee for Canadian tax purposes, which means that it can help a taxpayer avoiding the capital gains tax, the disincentive under Canadian tax law when gifts of land are made to it. A number of examples, the American Friends of Canadian Conservation has been involved in a number of transactions with US landowners owning land in Canada and wish to obtain a US tax deduction because they can convey that land to the American Friends, and then American Friends of Canadian Conservation is able to dispose of that property subsequent to the transaction in accordance with its own charitable purposes. And projects that this organization has been engaged in include projects in Nova Scotia, Ontario, British Columbia, particularly along the US border. A third way in which landowners have overcome the tax barriers to making charitable contributions of land has to do with making donations to a charity that's organized that is a large international organization, such as the Nature Conservancy, or as I said earlier, the American Friends of Canadian Conservation. In such cases, the donor of the land can, or donor of cash could donate their asset to the International Conservation Organization. And as long as the donor does not direct or require that gift to be passed through to another charity in another country, that donor would be entitled to a US tax deduction. And while they cannot require the gift to be passed through, they can express their intention or their desire that how the gift is to be used and still maintain their charitable tax deduction. The Nature Conservancy has accepted gifts under this arrangement, as well as the American Friends of Canadian Conservation. And as long as TNC or the American Friends accepts the responsibility to exercise its own discretion as to how to make such transfers, these kinds of gifts are able to secure US tax deductions. And gifts by US private foundations may also be made to foreign charities, but they are, if such gifts are made by such foundations, they are subject to what's called expenditure responsibility under US tax law. And this means that the foundation must exercise due diligence to satisfy itself that the charity receiving the financial contribution in another country would have been eligible to receive the charitable contribution under US law. That is, it is organized for a charitable purpose. It has adequate reporting and accounting procedures, and that it complies with being supported by other charitable entities. As we've talked about a little earlier, there are some prospects for a universal solution to thinking about cross-border land conservation charity. They might be through UN model conventions, through OECD model tax convention on income and capital, the possible conventions on climate change and biodiversity that have just been recently announced, but will be upcoming again. And even in some other forums like IUCN's Transboundary Conservation Specialist Group or the World Commission on Protected Areas. These are all forums in which this issue could be raised and mechanisms could be established to try to address this problem. And as we've heard earlier from the earlier speaker, there are hopefully initiatives that are being undertaken at the EU level. In any effort to try to address this issue or this challenge and to try to develop strategies to allow for more cross-border conservation transactions, obviously more research is needed. And one of the areas would be to assemble data about the extent of ownership and donors who are interested in such kinds of transactions, and to try to quantify how big the opportunity is to be able to offer incentives to people in one country trying to help conservation in another. And in order to be able to get data about the fiscal impact of charitable giving, that would help be able to advocate for what kinds of adverse impact there might be were these policy approaches to be enacted at different jurisdictions. Obviously, there are other examples, as I've tried to explain, that might be used as precedent. And it's always critical to ensure that you have constituents and stakeholders helping to support the initiatives that might be offered to change policies to facilitate these kinds of transactions. So with that, I'll stop, and I'll be happy to answer questions and look forward to the conversation. Thank you.